And good evening. Thank you so much for watching Life Ahead here on PBS Fort Wayne. I'm Mark Evans, your host. Of course, this program is a weekly program, and we try to provide as much vital information for adults of all ages. And I think you'll find this program very interesting because we'll be talking about high net worth estate planning. And some of the figures that our special guest tonight will give us, I think you'll be amazed at, to be honest with you, or maybe slightly astounded, okay? But we're going to invite your questions and your comments at the phone numbers that you see on the screen. If you'd like to call us and be on the air live, we love that, love the interaction. You can call 260-969-2720, or if you are too busy to get on the line with us and you just have a quick question, do that by texting us, and that number is 260-969-2730. And when you do that, let us know at least your first name and the town you're calling from, because we'd like to do a shout out. Our guest tonight, of course, he's back again, and we truly appreciate your support of PBS Fort Wayne.
My pleasure.
Bryan Nugen, who is he is an elder law attorney and an estate planner.
That's right. And
you always bring very good information. The last program we had, I was just so proud of the information that we provided. In fact, I had several people come up a couple of weeks after that.
Great.
Telling me that they really enjoyed that program.
Good, I'd like to hear that.
And tonight is something I don't think that we have discussed, at least while I've been a host of this show, but the high net worth estate planning.
Right.
And let's get started by you telling us and helping us understand what it means for a household to be defined as a high net worth family.
Okay, thank you for the question.
Sure.
So I think it's interesting when we talk about oftentimes on this show, what does it mean to have a lot of money, and that's different for everybody in their mind, what it means to have a lot of money. But by the numbers, if someone has $1 million or more to invest in the stock market, in CDs, stocks, bonds, those types of things, that's around 2 to 3% of our population actually has $1 million that they're able to invest. If we go to, so that's oftentimes called that's a wealthy population. If we move up to maybe $5 million, we have more high net worth individuals. They have $5 million or more to invest. And then ultra high net worth is, 30 million and above, which is very rare. Very rare that we have those.
And those
folks.
are the kind of people I hang out with.
Fair enough. That's good. You need to introduce me. So, but there's a difference between having money to invest in the market, have cash in the bank, versus someone having a net value that's $1 million or more. So when we're looking at net value, someone may be worth $1 million or more, and they're thinking, I don't have that much. I don't have that much in the stock market. I haven't invested that much. But if we take a look at the value of their home, so especially since COVID, I can tell you in northeastern Indiana, real estate prices have gone up significantly. So folks may be worth $1 million or more, but they don't have that much to invest in the stock market. So folks that are worth $1 million or more net, meaning after we take all of our assets, we subtract all the debts that we have from that, what do we have left over? So between 12 and 18% of the U.S. population has a net value, or a net worth rather, of $1 million or more. So when we're looking at doing estate planning for those folks, we may use a little bit of a different technique than for those that have less than $1 million to invest. But our listeners shouldn't be feeling like, oh my gosh, I should have $1 million or more to invest, because frankly, those folks that do, it's 2 to 3% of the population.
Yeah, and there's 150,000 millionaires in the state of Indiana. We went over these figures before the show and back in the green room. And then we figured out, in fact, it was in black and white there on paper, that 1 out of 17 people in the state of Indiana are classified as millionaires.
So that's the net.
But that's net.
That's net, meaning all of their assets, subtracting their debts, and how much money is left over. So I have my home, I take my mortgage off of that, I maybe have a 401k at work, some stock options at work, those types of things. So I may now have a net value of $1 million or more, but you can't invest your home.
Right. So what you're saying is, if you have a home that could be appraised for, let's say, $500,000, you're already halfway there.
You are halfway there, assuming you don't have debt.
Okay.
Right?
Now,
if you have debt, then that would affect your net.
And we're talking about a house that's paid off. Is that correct?
Yes.
Just because.
So net means the gross value, $500,000 in your scenario. If you have a mortgage, and let's say you have a $200,000 mortgage, I take the $200,000 from the $500. My net is $300,000.
Okay.
So your figure saying 17, my figures on a national level,
right,
which is 12 to 18% of folks are worth a net of $1 million or more.
Okay.
Yep.
And we're seeing more and more of that these days, correct?
Well, I think, especially with real estate, farms, northeastern Indiana, northwestern Ohio, Michigan, we're seeing farm prices go sky high.
Yeah.
I did a presentation recently, and someone in the audience indicated that farm ground in their area is selling for around $18,000 an acre. So, yeah, farm ground has gone very high as well.
Okay. Well, so you mentioned this earlier, you touched on it just slightly, but what actually separates a high net worth estate plan from a standard estate plan?
Well, I think it may require a little bit more attention and a little bit more detail about how you're wanting to pass that wealth to the next generation. You may be a little bit more able to create a legacy for yourself, meaning maybe I'll create a trust that pays out over a period of time. So instead of distributing my wealth immediately upon passing, I may say, I want my kids to work a little bit harder. So in the trust, I'm going to put some funds aside, and I would say to my children, for every X dollars you earn, this trust, this money I've set aside for you, will match that which you earn. So instead of giving money outright, I'm going to motivate my child and say, for every dollar you earn, I'll give you $1. Or for every dollar you earn, I'll give you 25 cents on the dollar. Sometimes we also put in our estate planning for folks that have a little bit more wealth, more significant wealth. We want our children to be philanthropically minded. So we're encouraging our children to use a percentage of the estate that the parent has and make decisions about how that should be invested philanthropically. So So maybe we set some aside for PBS. Maybe we set some aside for another favorite charity or religious organization. So within that planning, where the parents may be teaching or the grandparents may be teaching their children, their grandchildren, to have that mindset to give back. And so there's having a percentage of their estate that the kids, the grandkids, can make a decision about what charitable entity receives that money.
Okay, so yeah, I can see the difference there. Now, of course, when I think of a high net worth estate, I'm thinking taxes. I mean, I'm always thinking taxes.
Yep.
So how much does an estate need to be for taxes to be paid? Where is the line there?
So there was a time in Indiana where estates were subject to something called inheritance tax. We don't have inheritance tax in Indiana any longer. So there's no inheritance tax that's due to the state of Indiana when a person passes away. That's gone. On the federal level, so April, right? When you file your tax return in April, you have a state tax return, a federal tax return. Same thing in estates. So on the federal level, you would have to have, if you're a single individual, $15 million or more before you pay any federal estate tax.
Wow.
And then if you're married, you can take your spouse's credits. So if you have $15 million worth of credits, your spouse has $15 million worth of credits, we now as a couple can pass $30 million or up to $30 million before any tax is paid. So you'll recall at the start of the show tonight, I was talking about ultra high net worth, $30 million or more. It's a very small percentage of our population, significantly less than 1%. So it's a rarity anymore that attorneys, when they're assisting their clients and they're going through the probate process and taxes being paid, that there's a real concern about tax being paid. So I'd like for folks to hear that, because one of the first questions oftentimes estate planning elder law attorneys get is, gosh, I want to make sure I don't pay any tax when I pass away. I want to make sure my kids don't pay any tax when I pass away. What can I do to avoid tax? And so the first question that you may be receiving in that meeting is, well, let's talk about your net worth. What's the value of all of your assets, gross value of all of your assets? Do you have any debts? Let's subtract those. What's the net? And then we compare that to the 15 million or the 30 million, And a majority of the time, people's minds are put at ease. We don't need to worry about tax anymore. There was a time where we would purchase life insurance policies on folks. So if they passed, we were sure to have enough money to pay tax if tax was due when they're passed, when they've passed. But that is not happening on a very frequent basis anymore.
I remember that when my grandparents passed away. Yeah, there was some tax issues there.
Could be.
But nowadays, you don't have to worry about it.
Very rarely are folks paying tax when they pass.
And that's a good thing.
It is a good thing.
So I'm assuming that a simple will is not going to be enough for a high net worth family. Am I correct?
Well, this phrase, simple will, always confounds me because a will can be rather complicated and can be very robust. I think when we're looking at doing those special things that I was referencing earlier, maybe we're creating trusts that last for generations, or people don't get money for a period of time, and you start talking about the probate process, and folks are maybe wanting to avoid the probate process. They don't want to have to go to court when they pass away and go through that estate administration process. So it isn't necessarily that a will wouldn't accomplish the same thing as a trust would accomplish. It can accomplish the same thing. The difference is that with a will, if we're going through probate, then you have personal representative fees, you have publication costs, you have the attorney fees, right? And probate itself, it's not hard for probate to last a year, more or less. And the more complicated our estate is, maybe an individual has multiple pieces of real estate, they have different types of investments, then it makes more sense to use a trust. It makes more sense to avoid that probate administration process. It streamlines it, it reduces your costs, the money goes out a little bit more quickly. I shouldn't say a little bit more, fairly, significantly more quickly to those folks that you want to have it in the end, the beneficiaries that would be receiving it in the end. So it's not that a will wouldn't accomplish what you can accomplish with a trust, but as our estate grows and we're able to do some of those special things, and we want to avoid that probate process, normally a trust makes a little bit more sense.
So I guess my next question will be, you just probably answered it, but when a will does fail a high net worth family, and if you're not using a will, what do you use? Is that going to be the trust?
Well, it would be the trust. If you really don't have any estate planning in place, then we do something called intestate succession, which is a completely different discussion. But
I don't think I've ever heard that before.
Intestate succession. So intestate succession is if you pass, you have no estate planning in place, no will, no trust, no beneficiary designations on your assets, then the state of Indiana determines where those monies go. And it does typically stay in the family. Children, if you don't have children, spouse and children, parents, siblings, there's a whole chart that intestate succession determines how the money goes if you don't have a will. But we're hoping that people are organized and do get themselves structured. So if you don't have a will, we would go through intestate succession. If we're looking at doing some planning to avoid that probate administration process, we're wanting to set some special things in place, it normally makes more sense to have at least a revocable trust in place. But even with a revocable trust, we also have wills that are called pour-over wills, P-O-U-R, like lemonade into a glass, pour-over will, which indicates there's an asset that I have. Could be a bank account, could be a brokerage account, could be a piece of real estate, something we forgot to put into the name of the trust or we failed to put into the name of the trust during our lifetime. That pour-over will would pick it up and pour it into the trust at the time of our passing. So if someone's doing a trust, it would be a very rare instance that they wouldn't also have a will. They should have both.
Okay.
Yeah. But we hope never to use the will. We hope that all of our assets are in the name of the trust, so I can avoid going through probate. That pour-over will is just in case we forgot to put something in, just in case we can pick up those assets and pour it in at the time of passing.
So, and then we've had this discussion before when you were on, the trust takes care of the probate, right? You don't have probate with a trust?
So a trust will avoid going through probate, assuming it's properly funded, meaning all of your assets are in the name of the trust, it's properly prepared, it's signed appropriately, etc. Then yes, a trust would allow you to avoid that. And so we've mentioned this before as well. Inside that trust, we may have language that pays attention to if I have a child that maybe has a dependency issue, we can include language that says if they're not doing well at that time, they still may inherit, but our trustee may manage how they're giving that money out as opposed to giving a fair amount of wealth to somebody at the time. We also could include any of those types of language, any of that language that I was referencing before about, I don't want my kids to get the money all at once. Perhaps they get it at ages 25, 30, 35. I want to create trusts for my animals. I have animals that I want to provide care for a long period of time. We can do that. So the trust can take care of any of that for us past death.
Okay. If you're just now joining us, this is Life Ahead on PBS Fort Wayne. We're talking to Bryan Nugen, who is actually an elder law attorney and an estate planner. Some very interesting conversation going on here this evening. Please give us a call or a text at the numbers you see on the screen. We still have about 10 minutes left in the program. Bryan, you mentioned earlier about how you got to keep your kids working and give them incentives to work and have a career.
Yep.
But there's got to be some sort of a structure, and I'm sure there's some writing involved in putting this down. But how can trust be structured to protect children without completely removing their incentive to work and to actually build their own careers?
Sure. So so a trust is really just a contract. That's how I think of it. It's a contract, and there are generally three parties to that contract. One is the settlor, the grantor, the trust maker, the person that makes the trust. So that's the person that's doing their estate planning. That's the money that has the wealth. And so they're creating that contract. The next party of that would be the trust to that agreement, that trust agreement is called a trustee. So they're the individual that's responsible for complying with the terms of the trust, doling the money out as that has been written in the trust. And then the third party would be a beneficiary. And I think of lifetime beneficiaries, and I think of ultimate or death beneficiaries. So during the lifetime of that settlor, the grantor, the trust maker, the person that wrote the trust, who gets to enjoy the wealth from that trust? And then when that person passes, ultimately, where does the money go? So within that agreement itself, if we were wanting to motivate our children to work, for example, I think I gave that a few moments ago, which would be, if you earn so much money, then we're going to, the trust will match that. Or if you give money away, the trust will match that. So I like to say to people, when they're thinking about how they want to create that legacy for themselves for the next generation or the generation after that, dream. Right? What is it that you want to see in place? You don't need to worry about legalese when you're speaking with your attorney. You don't need to worry about the appropriate language you were referencing, Mark, to use. Allow the attorney to do that for you. So come in with a dream. What is it that you want to get accomplished? And it doesn't have to be in black and white. Think about, here's my estate as a whole, and what percentage of that do I want to go to charity? What percentage do I want to go to my children? What do I want to do with that wealth that I've been able to amass during my lifetime? So dream and bring that to your attorney and allow them to put that in black and white. And what I've often found is that when folks then see that in black and white, they may change their mind. Oh, now that I'm reading it, I don't really like how that is structured. I don't want the money to sit there for just an extended period of time. That wasn't my intent. So you're thinking that through with your attorney, you're talking it through. They should be challenging you a little bit, not in a negative way, but making you think about it from many different angles. So dream if you're wanting to do that legacy planning, and to bring those dreams to your attorney, and they'll help you sort that out.
Oh, that's great. That's great stuff. We do have a text coming in right now from Rosie of Traintown, Garrett, Indiana. Rosie, thank you so much for your text. She's asking, can you simplify your estate with beneficiary designations, which I think is a great question.
Yeah. Thank you, Rosie, for texting that in. I appreciate that question. So, yes, you can designate beneficiaries on investments that you have. So on a checking account, you can designate beneficiaries. On a savings account, you can designate beneficiaries. On your IRA at work, rather your 401k at work that may become an IRA at one point. My only caution about using beneficiary designations as your sole means of transferring wealth is that it doesn't have any of that language that I was just referencing earlier. So let's say that we're giving money to a child or to a grandchild with a beneficiary designation. And at the time that they receive that wealth, they're a special needs child. That could affect the benefits that they're receiving. That could negatively impact them. If we want to say, I don't want my grandchild to get the money at age 18, I prefer them to get it at 21 or 25 or 29, those beneficiary designations are enabled to do that. So while beneficiary designations can work, I'm hesitant to say that that is the means of, or the best means of making your estate simpler or making it streamlined. So that could be a part of your estate planning, but I would caution you against using that as your sole means of estate planning.
Okay.
Yep.
All right. Another text coming in right now from Tom of Columbia City. Hello,
Yep.
Columbia City. And Tom, he is asking, is putting a family business into a trust a good idea?
Yeah. Thank you, Tom. That's a great question. So yes, I think it's a great idea. So the family business, depending upon how you want to handle that. So as part of your estate planning, Tom, you could, for example, structure your family business where there are voting shares of stock in that corporation. There are non-voting shares of stock. So the non-voting shares, it's a way for us to pass wealth to our children during our lifetime. They're getting some of the revenue from that business during their lifetime, but you may be the only voting member of that entity. So you're voting how the business is run, et cetera. So sometimes we do that during a lifetime. The beautiful part about using the trust with your business is we put that LLC into that trust, we put a sub-S into that trust, and then you can determine how the money, how those shares are distributed as you in the trust itself. So as you pass, how those shares go out to your kids. If you want the business to be run for a period of time and they get some of the benefits from the income from that business, but you don't want them to have the stock immediately, we can control for that. So you can control how the stock from that sub-S goes out, the shares from that LLC go out after your passing. So the fact that it's a family business in and of itself doesn't mean that we shouldn't put that into a trust. Every asset I like seeing in a trust. It makes sense, it's appropriate, you avoid public being able to see what's happening in your estate planning. Trust keep it private. So I like putting closely held corporations, closely held limited liability companies in those revocable trusts. I think it's a great idea.
All right. And so once we have, for the high net worth estate planning, once we have all that in line or planned out, are you good to file it away, or does somebody need to revise it from time to time? How does that work?
So first of all, yes, you should file it away. So it's someplace that's safe.
Safe.
But I say, at home in a fire retardant safe or something like that. Oftentimes now, digital copies of those things are made and maintained by your attorney. Originals, you may hold the originals, but the attorney has digital copies often. But I like to see folks reviewing their estate plan about every 5 years to 7 years. I always find it interesting when people review their estate plan and they're surprised. Oh, we did this. Or, gosh, someone's health has changed. Had I realized that at the time, I wouldn't include them. So I like to see estate plans reviewed every 5 to 7 years. So no, you don't do your estate plan, put it on a shelf, and never look at it again. You can do that, but it's a nice idea to be able to review it on a fairly regular basis.
Okay.
Yep.
I want to talk about irrevocable trusts.
Yes.
And how it can protect family assets from creditors while still benefiting the heirs.
Okay, so irrevocable trust. So an irrevocable trust is, we think of that as it's set in stone, can't be changed. So if you don't have control over it, your creditors can't get to it. So we look at those trusts, we are setting up who the beneficiaries are. Is it an income alone beneficiary, or can that beneficiary get to the principal? So if that beneficiary has creditors, if they have debt, we can structure those trusts so that the creditor couldn't get to the assets inside of it. And for the individual that's preparing the irrevocable trust, we may want to protect our assets so that if we do have litigation, that creditor can't get to the assets that we have in that trust. So yes, irrevocable trust can be a large part of protecting assets from concerns about litigation, having creditors chasing you, your children, of course. That's appropriate, and it's used regularly.
Okay.
Yep.
We only have a minute left, and Rosie from Garrett has texted us again. Thank you so much. We love your questions. Can I protect my house from deeding to my children?
I don't know if I understand that. Can I protect my house by deeding it to my children? Mm-hmm. So if you're looking, Rosie, as you're aging, and your concern is that if I go into a nursing home or I need health care at some point in the future, those out-of-pocket expenses, I'm going to give it to my children, and that's how I'm going to protect it. I'm very cautious about gifting. Remember, I said to you early in the program, you can have $30 million as a couple. So we don't see gifting as much as we used to. When you gift to a child, it's the 4 Ds. If they have debt, divorce, disability, and debt. So debt, divorce, disability, and I'm forgetting my 4th D. But so be very cautious about making gifts to your children. You can lose your home. It's not a great way to protect it.
Okay.
They also lose a step up in basis for capital gains tax purposes.
Right.
Not a great plan.
All right. Good advice. And we truly appreciate you being here again,
Thank you,
Bryan.
Mark. Appreciate it.
And we'll see you in a few weeks, I think.
All right.
All right. And we hope to see you next week here for Life Ahead. And as always, we appreciate your communication with us and your viewership. And we certainly hope you have a fruitful life ahead. Thank you for watching.
The preceding program on PBS Fort Wayne is made possible in part by
Nugen Law, focusing on estate planning and elder care law, emphasizing independence and quality of life. Serving Indiana, Ohio, Michigan, and Florida. More information at nugenlaw.com.